on the phone, it is a pleasure to welcome to the program a legal historian of criminal law and procedure, the 20th century United States, teaching at the University of Iowa Law School, author of Open Road, How Cars Transformed American Freedom. Sarah Seo, welcome to the program.
Thank you so much for having me. It's great to be here.
This is a fascinating story, and it starts with let's actually start with how you came to choose this topic, because it's not the implications of the advent of the car on our law is not, something that's necessarily floating around the ether, right? I mean, it's just full of unintended consequences. I don't think they contemplated beforehand, and I don't think it gets much attention after the fact. But how did you come to write about this specific topic?
Actually, I started from the end of my book. I got interested in it because I wanted to look at the history of the war on drugs. The question really started forming when I was clerking in New York City for two federal judges, and much of the criminal docket in federal courts in New York were drug cases. And so I was really interested in how the drug war shaped our criminal procedure and criminal laws. And so what I started doing is, and I was really interested in the law enforcement of the war on drugs. And so if you wanted to study law enforcement as a constitutional matter, really there is one provision that is most directly relevant to governing what the police can do, and that's the Fourth Amendment. Because the Fourth Amendment prohibits unreasonable searches and seizures. And most police encounters with citizens begin with a seizure, which is a stop. A police stops someone and immediately the Fourth Amendment kicks in. And in that encounter, a search can happen as well. And so the Fourth Amendment governs that police-citizen encounter. And so what I did, I'm a historian, so I just started reading all Fourth Amendment cases from the very beginning of U.S. history. And what I found when I pulled up all these Fourth Amendment cases in Westlaw was really surprising to me. I can go on.
Yeah,
what surprised me. Yeah.
Well, I guess let's tell us what was surprising about these Fourth Amendment cases, and then I think we can circle back and talk about why there was a need for the development of this law, in the era as cars were being introduced in a mass way. But what were those Fourth Amendment cases that were so interesting?
Well, so there's two things that really stuck out to me. One was that Fourth Amendment cases were really rare until the 1920s. Some years, some decades, there were one or zero Fourth Amendment cases in state or federal courts. They started popping up a bit more in the late 19th century, but there was an explosion of Fourth Amendment cases in the 1920s, which goes to the topic of my book. It coincided with the mass production of cars. And when I was reading these cases from the 1920s on, so many Fourth Amendment cases had to do with car stops and searches. And so from the very beginning, I realized that this really is a story. The story of the Fourth Amendment is a 20th century history, first of all, because they were pretty rare before then. And second of all, it's a story about cars, policing cars.
That's fascinating. And let me and before we get into sort of the what the implications of the introduction of the car in such a widespread way impacted our society and policing. Why, like, give me a sense of like what the Fourth Amendment cases were before it started to involve a car. I mean, obviously, it's the Fourth Amendment. It obviously was on the minds of folks when they're drawing up the Constitution. What was the original construction, or I guess impetus behind the Fourth Amendment, and why was it so underutilized, I guess, or why was there less of a need for it in, let's say, the 19th century?
Sure. So I think you're asking two questions. One was, what was the original need for the Fourth Amendment? Why did the Founding Fathers include the Fourth Amendment as one of the amendments to the Bill of Rights? I think that's one of your first questions, right?
Yeah.
And then the second question is about what were some of the cases, the few cases that did arise, what were they about?
Right.
That's kind of the second question. Okay. So starting with the original purpose for why the Founding Fathers included it. So it went back to the experience during that led up to the American Revolution. We've all studied about how American colonists protested taxation without representation, right? England imposed taxes on the American colonists. They didn't want to pay, and so a lot of them didn't pay their taxes. And so what Parliament did was they passed these general laws. They basically passed a law that allowed agents of the king to stop and search anyone, anywhere, any place. They were called general warrants that gave agents, law enforcement agents, to search for tax evasion, basically. And
the tax evasion, just to be clear, I mean, my understanding is the tax evasion was a function of basically goods that we would, that from the king's perspective were smuggled. So if you had certain goods on you that you had not paid tax on, maybe didn't have the stamp or the wax or whatever it was that indicated that you had already, that you had paid taxes on these, they were contraband.
Exactly. And so what the Fourth Amendment requires is a specific warrant, right? It doesn't take away law enforcement's ability to search and to seize. What the Fourth Amendment says is if the government wants to search and seize, they need to have a specific warrant specifying who they're going to seize or arrest, what they're going to search, and where they're going to search. So no more general warrants that are enacted by law. Law enforcement have to go to a judge to get out a specific warrant.
The idea being that you need to be aware that there's been a specific, a case of smuggling or / tax evasion, however you want to call it, as opposed to I'm going to search every home and person and just fishing expedition at any and all times.
Exactly. What the Founding Fathers wanted to prohibit were general exploratory fishing expeditions, right? And so another requirement of the Fourth Amendment specifies is that to get a warrant, to get a specific warrant, the law enforcement needs to make out a probable cause, right? There's a reason why they want to look at certain places or to make an arrest. They have to articulate probable cause in front of a neutral magistrate. So that was the protection to prohibit general warrants from being enacted. So that's the original purpose. Go ahead.
Well, and then I guess, I mean, so the absence of needing the Fourth Amendment after, the idea of we don't have an outside force. I mean, what does the lack of invocation of the Fourth Amendment during the 19th century tell us about the dynamic of policing?
Sure. So there's two things. One is, so the Fourth Amendment applies only to the federal government. Before the 20th century, the federal government didn't really have a police force, a general police force. They had a really small state with very few law enforcement agents that really focused on discrete federal crimes. And there weren't a lot of federal crimes. Most of the crimes were tax evasion types of crimes, treasury crimes. Before the FBI, which is the main law enforcement agency today, the FBI was founded in, I believe, 1908. Before then, most of the law enforcement agents in the federal government were part of the Treasury Department. And so the opportunities for federal law enforcement agents to need to investigate crimes, and it was just not a common occurrence before the 20th century. So you don't really have the Fourth Amendment coming into play all that often. So that's the federal government story. My book also looks at what's going on in the state courts as well, right? Because there are local police departments or local law enforcement agencies at the local and state level, and all states have their version of the Fourth Amendment in their state constitutions. And so the question is, why don't we see more Fourth Amendment cases at the state level until the 20th century? And there's different reasons for that. Even at the local level, there weren't a really big law enforcement presence. There were sheriffs and constables. Some of the big cities by the mid-19th century did establish police forces, but they weren't as heavily staffed as one might expect. And that's because much of criminal investigation, prosecution, and enforcement was done privately. And what I mean by that is it was often private citizens and private businesses who investigated and prosecuted crime against the people who committed crimes against them. It wasn't a public police department or a public prosecutor. And so the Fourth Amendment really doesn't come into play in those cases either. So the development of modern police forces, which happens in the 20th century, leads to more Fourth Amendment issues. Before then, it didn't really come up.
Well, and that leads us to this sort of story of the development of the cars. And I mean, just give us a sense. I couldn't help but think when I was reading about the development, sort of the widespread adoption, I guess we should say, of cars in society, that one of the major sticking points in the libertarian presidential primary debates was the argument that we shouldn't have driver's licenses. Certainly the introduction of cars in the early 1900s, I can't remember the statistic off of my top of my head, but the number of like deaths and pedestrian death, I mean, give us a sense of what was going on with cars as they were widely adopted.
Right. So one thing to point out is that the mass production and also the mass adoption of cars happened really quickly. I think the tipping point in terms of a majority of American families who owned a car, getting past the 50% tipping point was happened sometime in the mid-1920s. So the infiltration of cars in American society happened really quickly, and cities and towns throughout the country were not prepared for the influx of cars on their streets and highways. So that's one thing. And so what that led to was this mass chaos in terms of traffic jams, in terms of just all of the cars on the streets, but also, like you mentioned, traffic accidents. And the fatalities rate was declared a national crisis by the Secretary of Commerce at the time, Herbert Hoover. There was one statistic that said that from 1913 to 1930, the death rate by car accidents increased, I want to say 400% or something like that, whereas death by all other types of accidents decreased 40%. And so the traffic accidents from cars made front-page news on the New York Times and newspapers throughout the country. It was a really big deal. And immediately, towns and cities started regulating the operation of motor vehicles, including driver's licenses.
So we have this. We adopt basically regulations and laws on how to drive and what constitutes traffic violations for the safety of individuals, but we have no mechanism at that point to enforce it.
Exactly. And everybody violated traffic laws, and it was a huge crisis. And
so at that point, is it just like a ton of help wanted signs like we need more cops? I mean, like what happens at that point? Because this is the first, I mean, basically the introduction of technology. And on some level, like this is like the story of societies, right? I mean, the introduction of this technology creates a whole almost entire new universe of potential obviously a lot of positives, but obviously a lot of potential negatives that only the state is able to step in and in any way, make it function in a way that, there has to be some type of, I guess, for lack of a better term, monopoly of force here. But there was literally no force to, I guess, execute that monopoly of force.
Right. So one of the main arguments that I make in the first half of my book is to show how American society as a whole shifted its very method of governing society because of cars. We went from a 19th century voluntary association, self-governance types of organizations that govern society to what I call 20th century police law enforcement as a mode of governance. So the problem of how to get people to obey traffic laws, right? How did American society get people to obey laws in the 19th century? It wasn't through police law enforcement. It was through voluntary associations like churches, trade unions, common law courts. People sued each other and, for trespass or contract violations or things like that. Those were the types of means used to make people obey norms of society. And in the first decade and two or so of the automobile, American society tried those 19th century forms of government to get people to obey traffic laws. They had associations like the California Development Association, the National Automobile Association, the Traffic Officials Association. All these different associations try to get together to try to convince people to obey laws. People volunteered to direct traffic. They had people. There was a safety pledge drive in California. They tried to get people to sign a safety pledge, pledging their honor that they would obey traffic laws. There was one county in California that put up a billboard saying our speed limit is 30 miles per hour. Be on your honor, obey it, so we don't need to hire more traffic cops. And so the whole premise of these voluntary associations is that that citizens are a part of a community and part of the local organization, and you could appeal to their reasonableness or their honor to follow the rules. And they tried that, and it didn't work. And so towns and cities had to hire more traffic cops. And what they were realizing was that all the fines that they could generate from traffic violations would pay for more traffic officers. And so that's how these modern day police departments grew. It was through traffic law enforcement.
So, and then, I mean, this is fascinating because they start as almost like these, I guess, traffic cops.
Exactly.
And it becomes, you write, the first time that the law-abiding, for lack of a better term, right? Like just sort of the average citizen who is not causing enough of a problem that other people say, hey, this guy's causing a problem, begin to have interactions with police on a regular basis.
Exactly. And it's actually law-abiding citizen is not, for lack of a better word, it's the phrase that they used themselves throughout the 20th century. What do we do with these law-abiding citizens who violate traffic laws? So it's that's a term that they use themselves. And one of the main arguments of my book is, it's surprising to find that the development of modern policing began because of the need to discipline the respectable, ordinary, law-abiding citizen. It wasn't because of the need to discipline the poor or the foreigners or immigrants. The population that we focus on today in today's literature about the vulnerable population subject to policing, the story, the history of policing, of modern policing, begins with this law-abiding citizenry.
That's fascinating. And then what turns is essentially starts with Carroll v. U.S., right? I mean, this is where, on some level, like is this the original sin? I mean, I don't know, maybe it's not even a sin, but this is where the dynamic changes, where essentially the court can't come up with a better way of doing this than basically allowing police discretion.
Exactly. Carroll versus United States was decided by the U.S. Supreme Court in 1925, and it was the U.S. Supreme Court's first car case. It actually came up before the U.S. Supreme Court in 1923, but the issue was so hard that they asked for another year. They asked the parties to argue the case again the next year, and they decided it in 1925. And the reason why the issue was so hard was because it's the juxtaposition of these two car stories, one about cars and freedom. It democratized transportation to a large numbers of the population. It was, the early adopters of cars were from the law-abiding class. So you have that story about cars and freedom and independence and all of that. But then you also have cars, and not just the need for policing, for traffic law regulation and enforcement, but you also have cars that really transformed the commission of crimes. The 1920s, which is when the mass adoption of cars is really gaining speed. 1920 is also when national prohibition is becoming enforced, becomes the law of the land. And bootleggers' favorite mode of transporting their liquor was the car, right? The car is basically, one way to think about it is a humongous movable container that can conceal liquor or other contraband. And it's easy to move boxes of liquor inside a car. And so you have law enforcement trying to enforce those laws as well. And so on the other hand, you want to be able to, the court wanted to be able to allow law enforcement to go after bootleggers, gangsters, and all that. So then there's these two different stories about the cars, two tensions that the court was trying to grapple with, and they had a really hard time grappling with it.
And that's the idea that one is like your property, it can't be searched, and the other is that it can't be searched without a warrant, I guess. And the other is that the mobility is such that you can't. It's tough to get a warrant because you go to the court and
there's
then
no time to go get one.
They drive off and deliver their liquor. And so the police are now armed with a certain discretion. And it's like the court's trying to split that difference between the British agents who would come by and just do a total fishing expedition, and the idea that that people could just drive off.
Exactly. So what the court did in the Carroll case was to say, we're going to create a warrant exception for cars, right? Just like you said, cars are private property, and so they are protected by the Fourth Amendment, which requires a specific warrant. But because of the specific, difficulties about cars, they're going to get rid of that warrant requirement, and the requirement is that the officer be able to articulate probable cause. If an officer believes that he or she has probable cause that there's evidence of a crime inside the car, they can stop and search the car without a warrant. And what the huge thing that decision does is that it transfers the decision of whether there is probable cause from a neutral judge over to an officer, and not just, and that's a huge shift for one thing, but also an officer on the road can decide at that moment whether to stop and search a car. And so I argue this is the first time that the court constitutionally recognizes the legitimacy of police discretionary powers.
And I mean, it's interesting. It just occurs to me that, like, that the sort of the solitude that I guess a police officer would do this in, right? I mean, this is, we're talking about on the road. It's not like there's a high amount of density necessarily, right, where this is happening, or is it? I mean, like the freedom that an officer has at that point seems to be pretty wide berth.
You mean the freedom to decide?
Yeah. Like
what
that.
To do?
Yeah. That.
Yeah. So the potential for abuse gets pointed out right after Carroll's decided. One commentator points out, the officer doesn't have to be 100% right that there's evidence of a crime inside the car, right? The standard is just probable cause, which allows room for an officer to be wrong about the fact that there might be evidence of a crime in a car. And so given that wiggle room, an officer could fudge the probable cause determination, right? He could have a mere hunch rather than probable cause, right? And if that decision gets challenged later in court, one of the commentators said right after the Carroll decision came out, there's something called judicial charity, where judges will be charitable towards the officer's determination of probable cause, especially if they're right, if they turned out to be right, that there was evidence of this crime in a car. So right after Carroll, commentators are criticizing the decision for giving too much power, putting too much power into the hands of police officers on the road. And this theme gets picked up again. It gets picked up in 1949 in another Supreme Court case, in a dissent written by Justice Jackson. And he outlines this pretty poignantly. He says, when an officer decides to stop a citizen on the side of the road, it's done in haste, right? A lot of these traffic stops, take place over a few minutes. There's nobody to oversee the whole process. And so the citizen who's pulled over can't ask for a neutral magistrate judge to make sure that everything's kosher. And if it's an innocent person who stopped, and the police let that person go away, then the privacy violations already happened, and the innocent person can't challenge that police action because there's no evidence of crime to challenge. And so innocent people have to experience potentially unconstitutional searches and seizures without ever having a court of law review that. And if you're guilty and there is evidence of a crime, there's, what the commentator said in the 1920s, judicial charity. And so a court is likely to see what the police did as reasonable because, the police was right. There was evidence of a crime. And so Justice Jackson was worried about how the way that the Carroll decision played out in practice would erode Fourth Amendment rights in cars.
And the problem then becomes, like, there's really two scenarios where that erosion becomes really problematic. I mean, broadly, and that is, one, you either get a bunch of police who are, who become obsessed with their power and decide to do this to everybody across the board, or it becomes a mechanism in which to I guess, act upon racial bias that you have, and that ends up being the problem.
Right, and we see that play out in the history of policing cars. And there's several stories that are coming together at this point. And one is, the criminal laws get developed over the 20th century. We had prohibition that lasted for a little over a decade. And then after that, we had various drug laws, which turned increasingly punitive after the 1970s. And so to enforce those laws, a lot of it which happened in the context of cars, officers need probable cause, and it's becoming increasingly easier to meet that standard of probable cause. But in a way, officers don't even need to articulate probable cause that there's evidence of a crime, because and this is the early history picking back up again, there's all these traffic laws that everybody's violating. And so the police can basically pull over anybody for a traffic violation. And in the starting in the 1950s, you see stories, or there are stories in the NAACP archives of the police using minor traffic violations to harass and abuse NAACP lawyers, activists. And one famous story is how Thurgood Marshall was pulled over for a pretextual stop, right? And Martin Luther King was pulled over for a speeding ticket. And there's all these stories in the NAACP archives of people who park right outside the NAACP offices who are ticketed for a minor traffic violation. And so there's these stories about the stories of traffic law enforcement and criminal law enforcement are coming together at pretty early in the 20th century.
And so does this, I mean, it feels like this slippery slope, I guess, which was a slippery slope. I mean, on some level, that the only thing that in some way seemed to at least plateau it, I guess, was really in many respects the advent of cell phones. And perhaps, it seems like the case law has actually probably continued down that slope a little bit in terms of allowing police these powers, not the least of which is their ability to confiscate goods if they suspect you involved in drugs in some instances, almost like a pre-punishment. But there's also, it seems to me, to be the problem that this dynamic, this principle in terms of giving the police discretion, crosses outside of traffic and cars into just policing more generally. Like when you start to get like stop and frisk and stuff like that. Is that part of the story?
It is, and I talk about some of the new data privacy cases in my epilogue, because I do see old themes about the cars popping up in these new cases about smartphones and data privacy in interesting ways. And so, for example, one of the themes of these Fourth Amendment cases in the 20th century about policing cars, one of the common themes is everyman or the law-abiding citizen, right? If the courts allow the police to do this, then that means that the police can also harass the everyman or the law-abiding citizen. And this was a theme that was made by Carroll in 1925. His lawyer argued, if you allow the police to do this, who else is going to be harassed? The rural postman, the milkman, the everyman. In 1949, Justice Jackson also said we have to treat the search of this bootlegger as a search of every man. And so there's this, because of the way that the car democratized mobility, lurking behind these court opinions is how is this court opinion also going to apply to everybody else? And I see that theme coming up again in the smartphone cases where the court's opinions point out so many of us have smartphones, and the justices are probably thinking, I have one too, right? And so in the one of the last smartphone decisions, Riley versus California, the opinion points out like 90% of Americans own a smartphone. So whatever we allow the police to do in this case is going to affect everybody. So that's one of the themes that are coming up again. The other interesting theme that I see, which is kind of a deviation from the history of policing cars, is comes from one argument that I make in my book, that the conventional story that we have been told about the Fourth Amendment is a story of progress and triumph, where the courts have been in a position to expand individual rights and protect individuals from the police. That was a story I was told when I went to law school. And it's a story that really focuses on the Warrant Court. The Warrant Court was the court under the Chief Justice Earl Warrant, mostly in the 1960s, one of the most liberal courts in U.S. history. That was a court that decided Brown v. Board of Education, that eliminated or said segregation in public schools was unlawful or unconstitutional. And the Warrant Court was also the court that started the due process revolution. Right? We call it a revolution because the court basically started applying the U.S. Constitution, which only applies to the federal government. They started applying it to local police officers. And so the U.S. Supreme Court started policing the police, and it was a huge revolution. And it's a story of triumph, basically. That was a story that I've had for ever since in law school. And what I realized when I read all those cases, those landmark cases that we celebrate for protecting individual rights, all of those cases don't have anything to do with policing cars. They're all about protecting the home or the house, which is the most protected space in constitutional law. And when I started looking at all the other Fourth Amendment cases that even the Warren Court decided about policing cars, it's in the car cases where the court actually expanded the police's discretionary power. So it's my book kind of revises a little bit the standard story about what the courts did in terms of developing the Fourth Amendment in the 20th century. So I go into all of this to say how the smartphone jurisprudence is deviating from the history of policing cars. What the court said in one of the last smartphone cases is to say smartphones is actually not like cars. Usually anything that you could put into a car is considered part of a car search. Like if you have a purse inside your car, that can be searched as part of a car search. And so one would think that a smartphone in your car could be searched as, it's found inside the car. But instead what the court said was, a smartphone is more like your house because it contains books. It contains more books than the smartphone has more books than many people have in their homes. It contains medical records that you might keep a safeguard in your home. It has conversations with friends and texts, and conversations with friends can happen in a home. So what the court did was to say smartphones are not like cars, it's more like houses. And therefore, we're going to require a warrant if the police want to search your smartphone. And so that metaphor of is it more like a car or is it more like a house still shapes how the court decides whether the Fourth Amendment is going to apply to different and new technologies.
Fascinating. The book is Policing the Open Road, How Cars Transformed American Freedom. Sarah Seo, thank you so much for your time today. We'll put a link to the book on majority.fm.